Hi guys, Toby Mathis here, one of the partners at Anderson Law Group and Business Advisors. And a question we oftentimes get, and me personally, I've gotten this hundreds of times over the years, is do I need a will or living trust? Subscribe to the YouTube channel, click the bell notification icon so you know when a new video is uploaded. Tax laws are changing all the time. The laws are changing all the time. That's why you're first to know, you're first to grow. And that's not to say versus will or living trust. That's just to say, do I need any estate planning whatsoever? And the answer is almost always the same, which is yes. You absolutely need to do something in writing, because if you don't put it in writing and something happens, then it's too late. And I'm not saying death. This is what's really important, is there's lots of stuff that could happen during our lives where we need some sort of documentation that needs to be in an estate plan. So step number one is making sure that you have somebody to advocate for you, your body, in the event you're not able to advocate for yourself. So for example, if you go into a hospital and you're going in for a procedure and they put you under general anesthesia and you're out, you can no longer answer questions, right? So you got to have somebody designated to answer those questions for you. And if you think it's automatic, here's news for you. It's not. And so you're literally putting your life into somebody else's hands and for somebody else to make that decision, but you're not designating who gets to make that decision. So first step is to make sure that you put in writing who gets to make that decision. If it's your spouse, or if it's somebody who's a caregiver, or if it's a sibling or a child or a parent, somebody that you're designating, and then you're giving them access to information so that they can make the best decision for you. So for example, if again, same scenario, I go into the hospital and let's say that I'm going in, I've had knee surgery and I was out for knee surgery. If something had come up and there was a decision that needed to be made while I was out, they would have asked my spouse. But I also gave a HIPAA release so that my spouse could get the medical information to make that decision. Now, it's really easy when it's a spouse. It gets far more complicated when it's a partner, fiance, parent, child, sibling, third party, best friend, whatever. You need to have that or they're not going to give you that information. They're not going to give that individual. So that's number one, is always making sure that you have medical covered. Number two is finances. If I'm not able to make decisions for myself, then I need to have somebody appointed for me. Otherwise, the state's going to get involved. And I don't want the state involved. That's almost never a good situation. And so again, let's say the most common example, nowadays we're just getting older. Sometimes our bodies are outliving our minds, right? Sometimes we need help. We are not good at making our own decisions. In my family, we were touched by dementia. A lot of you are going through that same thing. I had a parent that was not able to make decisions for himself. And luckily, in writing, had already designated my mother to make those decisions. My mom, if it's same scenario, needs to have somebody appointed. Could be her sister, could be one of her kids, could be her attorney, could be another fiduciary, could be her best friend. Having somebody appointed to make decisions is critical, because when you get to the point when you can no longer make those decisions, it's too late to pick somebody else. And now you're out of luck. Last point, and this is the big one that everybody immediately jumps to, is what happens when I pass? And you have three options. You either have a will where you've said, here's how I'm distributing my assets. And that requires that you go through the court system. I have nothing. That's called intestate. And now your assets are divided under the laws of the state in which you reside. Number three is I have a trust. And a trust is the only one of those three that does not require court supervision. So you tell me which one you would rather have. Two of the three require that your heirs go through a court process and go through and deal with a judge and lawyers. The third avoids it entirely, can be much faster, and could have, again, the expense of probate gets avoided completely. So if you're somebody, you don't have much of anything, you still need an estate plan because you still have your body. Let's say I don't have a lot of financial successes. I don't have a ton of assets. That's fine. You still need somebody to answer questions for you, for your body and for your finances, should you not be able to. And I don't care whether you're just collecting Social Security, you still need to have somebody there to represent your interests, because if you don't, that's when bad things happen. And then for all of us, rare is the case. In fact, I've almost never seen it when it's going to make more sense, all things being equal, to go with a will or nothing versus a living trust. And I would say if I had to rank them in order, the best is always going to be a living trust. The secondary is a will with a good power of attorney for finances and a good power of attorney for medical and a good HIPAA release. And then by all means, please make sure you're giving away your assets, things like your fine china or your jewelry or things like that to specific people, because that's where the fights really occur, is when there's an emotionally charged situation. Please make sure you're doing that. And if it ends up in a court situation, that's usually where fights break out. And then the last one, and the one to avoid, is passing away with nothing. And frankly, I would say it's not just passing away, but it's if you need help and you need a third party to help you, and not having documentation, it could be just atrocious. And so I would say, again, if I had to put them in order, number one, absolutely is going to be the living trust. Number two is going to be the will with a good power of attorney and healthcare power of attorney. Make sure there's one for finances, one for healthcare, and a good HIPAA release to make sure that they have access to the information. And last, and the one to avoid, is passing away with no paperwork whatsoever. So I hope this is helpful for you. And if you feel like it, please share it with somebody who's struggling with these issues and has that common question, which is, what happens if I die with nothing, or a will, or a trust?